Folks, do you get confused about the regulation around medical device cybersecurity in the EU? Well, I certainly do, and I think a big part of it is the vast quantity and complexity of the regulation we have here on this continent. Today's guest, Elisabetta Biasin, is a law researcher, and I found out about her outstanding work in Chapter 4 of a book called The Future of Medical Device Regulation. What an ambitious title. And there she explained the relationship between NIS2, GDPR, the AI Act, and MDR, Medical Device Regulation. Stay tuned for our most regulation enlightening episode yet. So without further ado, Elisabetta, welcome to the Medical Device Cybersecurity Podcast.
Thank you very much. Thank you for having me today. I'm excited.
Yeah, it's a pleasure to have you. Nice. Elisabetta, perhaps can you introduce yourself? How did you make it into medical device cybersecurity regulation piece? What's your journey here?
I'm a researcher in law at the Leuven Center for IT and AP Law. And I'm involved in several projects on cybersecurity and healthcare. Now, less cybersecurity, but still healthcare. And I was researching a lot on medical devices and especially the effects of security of medical devices. And I realized that it was quite interesting to see the new regulations, cybersecurity regulations, how they were applying to medical devices, how they could be in interplay with that regulation. So I started my research like this. And along with my colleague, Erika Menjasevic, we wrote a couple of papers, and we also did some comparative research a couple of years ago at the Stanford Law School. And we basically made some new analysis as soon as the AI Act came into the policy table, and we started also researching on AI-based medical device cybersecurity. So our research evolved a lot, and we kept our interest in that topic.
How long ago was it that you started looking at the topic of AI?
The topic of AI started in 2020, while without AI, it was 2019. Our first search item on MDR and cybersecurity requirements.
Oh wow, yeah, MDR changed a lot of things for us in the industry. So Elisabetta, can you tell us what the EU means when it talks about AI, artificial intelligence?
Yeah, so an interesting thing is the fact that before these huge discussions back in the last 5 years, there were no agreed definitions of what was an AI system, and still now there are many discussions about its definition itself. For the AI Act, an AI system is a machine-based system that, according to the definition, it has to operate with different levels of autonomy, and then it can show adaptiveness after deployment, and for specifically some explicit or implicit objectives. And another characteristic that is really important is that it infers from the input it receives and generates outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. So it's quite a thing also for medical devices, because AI systems can be used also in the context of healthcare, and therefore predictions, recommendations, and decisions can definitely influence the physical or virtual environments in the health domain for patients and for doctors.
Yeah, I have a question about the definition you just gave. That you said something about intrinsic, extrinsic. What was it referring to?
So explicit or implicit objectives.
Yeah, right.
So when there is an entity that develops an AI system, it may have declared objectives, and from these objectives, they can be explicitly stated, but also in order to have a more encompassing definition of the meaning of AI system, the legislator wanted also to make the case of having both explicit, or what you declare that you have as an objective, then also what can become an objective itself. Because the idea during the discussion of the AI Act was to have an encompassing definition that could somehow bring certainty and, to a certain extent, also quite some guarantees for the persons that were impacted by these kind of regulations. And in this sense, as I will also say maybe a couple of words later, it was quite centered on individuals and fundamental rights and things that were related to the protections of individuals and the possible harm that will come from the AI Act.
Okay. Makes sense. Can you tell us a bit more about the AI Act? What is it and why should medical device manufacturer care?
So the Act is this regulation that was approved, and it's really important in the European Union, and it's really important for medical device manufacturers because it concerns and it may apply, very simply put, to medical devices.
So why may?
So there are some exemptions because, for example, you have the research exemption that was quite discussed before in the last month. But basically, it's also my lawyer's language, but it's applying for the majority of medical devices. Why I'm saying so? Because there is a specific article, which is Article 6, that provides for the applicability and the classification of AI systems. So how does it work? It works that the AI Act regulates AI systems and provides for some specific example of high-risk AI systems. So it poses different degrees of risks for those AI systems, which the definition I gave earlier a little bit before. And based on the risk that is assigned to those AI systems, it provides some requirements. And there are many requirements that may apply for those AI systems. And medical devices are explicitly included, as I was saying, especially except for some exemptions in Article 6. And their specific mention, you can find it in Annex 1 of the AI Act. So it's really there. And the requirements are not just on cybersecurity, but there are many other requirements for those high-risk AI system.
So can you give us an example of a cybersecurity implementation that you have, and some non-cybersecurity, just so I have an idea of what it looks like, the text?
So the thing is that in the text, we don't have the same approach that you would expect for cybersecurity, especially in the Act. So the AI Act includes the reference to cybersecurity is small, and it's very general. And it's contained in Article 15 on the AI Act, where it says that high-risk AI systems shall be designed and developed in a way that they achieve an appropriate level of accuracy, robustness, and cybersecurity, and then they perform consistently in those respects throughout their life cycle. And then there is another paragraph that's really deep delves a little bit into it, and it's about the possibility to high-risk AI system. They have to be resilient against the attempts. For example, if you have an unauthorized third party to alter the use or the output of performance of system vulnerabilities. And then it provides examples on how technical solutions could help ensuring cybersecurity of high-risk medical devices. And it suggests that it should be appropriate to the relevant circumstances of risks, which means it's a broad provision for high-risk AI systems that may apply for high-risk AI systems. At the same time, what is important to note here, it's important to have this provision in the AI Act, but at the same time, there are other provisions that are more detailed, that are present in the MDR, that are concern medical device cybersecurity. So it's interesting to see that they should interplay, and to see that in some ways they could bring different outcomes, let's say. And another thing that I think it's important is the fact that there is a presumption of conformity with cybersecurity requirements in case you have a cybersecurity certification according to the Cybersecurity Act, which is something that's not written in the MDR because the MDR doesn't talk about explicitly cybersecurity. The MDR, talks about safety and performance requirements of medical devices, and those safety and performance requirements were interpreted by the Medical Device Coordination Group as cybersecurity requirement. There has been a guidance, etc. Which, by the way, it's a guidance that needs to be maybe updated.
Oh, really? I haven't heard that one. It needs to be updated?
I think this is not only my opinion, but with some colleagues of my research center, I would like to acknowledge the opinion of Dusko Milajovic. There is this guidance that was produced in 2019, and it's about cybersecurity of medical devices.
Yeah.
It's, I think, 2019-10. The problem is, in my opinion, and I think it wasn't updated since then, was because they knew there was the AI Act coming along, etc. But there are so many different things that, like, there is a small section in the last page of the of this guidance, but the guidance do not talk about AI, and there are other
Maybe.
regulations. So the Act is not included. There's no specification on how this could interact. And I can also understand it because the medical device coordination group is not addressing AI specifically, wasn't at that time. But I think it would be a nice time to have an updated version, also in light not only with regard to the AI Act, but also with regard to the NIS2 directive and the Cybersecurity Act itself. So it's really something because we had these guidelines, and it's nice. It was the first guidelines in the EU on medical device cybersecurity, and before there was nothing. But at the same time, I think it's a good moment to have a new one. It's 6 years later. I think it would be a nice moment.
Absolutely. I mean, it's so confusing. I mean, the landscape of how we build medical devices has changed so much since 2022, really.
Yeah.
So yeah, it's definitely time for an update. So today, February 21st is the time we record this, folks. If you're a medical device manufacturer, you want to implement you want to sell your medical devices in Europe, and you have some AI component to it, you want to know what you need to look at in terms of cybersecurity, where do you look?
So you need to look at, as I was introducing the AI Act, Article 15, whether you are performing research, so Article 6 of the Act, and see whether there are some exemptions, which are exemption until you want to deploy, of course, the medical device in the market. And then besides the AI Act, of course, you have the MDR, safety and performance requirements and guidance helping you on that. Then you have also to consider the NIS2 directive. Of course, it depends where you are based, because so far we were talking about AI Acts and the MDR, which are regulations, European regulations, which means that they've been issued and they apply directly in all the member states of the European Union without the need to have a national law implementing it. But with the NIS2 directive, it's different. It's a directive, which means that it has to be harmonized across the member states, and therefore there are different national laws for every member state that will give specification to what is written in the NIS2 directive. And the most important aspects of the NIS2 directive is the adoption for medical device manufacturers of security measures and a risk-based approach, and to notify incidents to the relevant authorities. So, and beyond that, it's the GDPR. Don't forget about the GDPR.
Wow, this one's the old one in all of these, right? Yeah. AI is fresh, NIS2 is kind of fresh, and GDPR is the old one. I mean, let's move on to NIS2 for some time. If you're a medical device manufacturer, NIS2 doesn't just impact, I think it's the one regulation that doesn't just impact the medical device, but also the security of the organization as a whole, right? Can you tell us more about that?
Yeah, so the NIS2 came after the NIS1. So basically, it was the first horizontal piece of legislation that was approved in the European Union that started talking about the security and then cybersecurity. And it's quite interesting because before the NIS directives themselves, there were no specific pieces of legislation. So it has been a process, let's say. And initially, with the first NIS directive, there was no specific mention to medical device manufacturers specifically. It was mostly referring to specific sectors, the healthcare sectors, and it was the case of having in the scope of this directive healthcare providers, which in other words are hospitals. And with the first NIS directive, which it was kind of mechanistic approach, you had to identify the specific healthcare providers, and the more every member state had to do it. And then they soon realized that the entities in the European Union that were kind of revising the directive, soon realized that there were different approaches in the member states for hospitals. So this led, among other things, but the main problem was fragmentation, different application of the NIS directive across member states. This led to the revision, and it led to the NIS2 directive. And first, the NIS1 directive, it talked about security of network and information systems, and this was the core concept. And what's interesting for the NIS2 directive, it's the small but significant shift because it's now about cybersecurity across the union. And it's for cybersecurity legal researcher, it has been a big shift because
Oh yeah.
it's not, because the NIS1 is more about security of network and information system, which was defined specifically and was also considering network information system, including devices. But here, the definition is about not only the systems, but about the specific cybersecurity term and definition, which has also a more holistic scope because it also encompasses individuals in its own definition. And the definition came between the two acts. It came with the Cybersecurity Act in 2019. So it seems like a small thing, but in reality, it had this kind of impact, this definitional aspect. And besides that, another important modification that was brought was the fact that the healthcare sector was not only impacted for healthcare providers, but it had new actors, for example, medical device manufacturers, or in other case also EU laboratories specifically and entities that manufacture critical medical devices in specific circumstances. Okay. So it's encompassing more things in the healthcare sector.
Yeah, I remember people were panicking about the idea of awareness, of threat awareness, teaching people in the organization, how are we going to do this? Is phishing simulations enough and everything? So if we think about the application of NIS2, and is it something that you can have auditors come into your organization and check that NIS2 criteria are well implemented? How does it work? Are there checks? Have people been fines on this?
So on a practical level, what I would suggest to do is to see, nationally speaking, what is happening, let's say. Then, of course, there are some pieces of guidance that are out that are not, by the way, binding themselves. ENISA produces some interesting documentation. So my answer would be to check at national legislation. Then in practice, I'm not sure if I have a specific reference document, but I would suggest to check on a national level because the main requirements are of interest. It's when you have to notify specific aspects, you need to notify to certain authorities, and the modalities are determined on a member state level.
Yeah, and then the fine can come in whether, I think what I saw is that it can come in whether there's been a lack of controls. Once there's a cyber attack and you declare it and you've done all the process, the state will be much more understanding than if you don't declare it or if you don't have the controls in place that are required by NIS2. So yeah, definitely a big one. Is there such a thing as overlap between NIS2 and the MDR?
So in our former writings, we analyzed this specific topic, and we analyzed especially the case of serious incidents. And in our previous writing, while there was still the proposal back and forth, we suggested that there were some provisions that need to be modified about the interplay between the NIS and the MDR. And basically what I'm talking about is serious incident notification concerning the MDR, which has a specific definition itself, and incident notification as per the NIS2 directive. We also thought, okay, with AI-based medical devices, maybe also the Act is coming into play because there's, surprise, also norms on serious incidents within the Act. And while we were writing our paper, we were oh, this sounds quite complicated, because before the last version of the VI Act itself, it was also a requirement to have a serious incident notification that really resembled as the one from the medical device regulation. But rechecking the final version of the Act, I now see that it's a slightly different. While the MDR, it's more about protecting with this serious incident notification, the health of the patients. For the Act, you will have to do a serious incident notification where there is harm to property or environment. So in the Act, there was this attention to say, okay, let's try not to overlap with what is
Good
already
work.
written in the MDR. And specifically, there was an exception. There is written an exception specifically, because usually for the Act, you will have also to notify for other kind of breaches that have more implication for persons. But in that cases, it would not apply. So
Yeah,
it's quite complicated.
for sure. And I think a lot of the work has to be done beforehand. If you have time right now, probably you don't, but you should take it to understand a bit more about what are the requirements when that serious accident happens, whether it's on a list level, whether it's on an AI legislation level, taking some time, because some of the countries, I'm talking about France, the notification period is only, I think it's 24 or 48 hours for essential entities. So definitely something to be aware of, because otherwise it can hurt you if you don't do these declarations on time. And same goes for MDR.
Totally.
Talking the older legislation that maybe doesn't receive as much attention as should, GDPR. So today it's been a while since GDPR has been introduced, and a lot of the companies that are out there have already adapted their way of working to GDPR. If you're a new medical device manufacturer and you're looking at GDPR and you don't know where to start, what would you advise them to do?
So the first thing is that I always advise to do to anybody in the healthcare sector before starting understanding what is relevant for the GDPR itself is, okay, understand where you stand at, where you're processing personal data. So depending on what is your role in the data processing, you will have different requirements. So to put it simply, something that is said very simply by the data protection authorities, if you determine the how and why of the processing, is likely for you to be the controller of the processing, which means that you will have quite an important set of requirements. If you are, on the contrary, the processor, then you will have to follow the instruction of the controller, and in that case you have not less specific, but different requirements. So my first suggestion is understand very well what is your role in the data processing. And when it comes to security, the most important aspects, there is a specific principles in the GDPR that you might be already aware of in Article 5, where it's written how the processing of personal data should be in a secure manner. And there is a specific section in the GDPR where it's about the security of data processing. So I would say to manufacturers, go to the security of data processing section and have a look. And among the many things, there are provisions on security, but also you won't maybe expect it at the first time, but the data protection impact assessments, where part of the process is on that. And then, of course, there is, earlier we talked about serious incidents and incident notification. There is also provisions on data breach notifications to authorities and individuals in certain circumstances. And in certain cases also there are some provisions on keeping record of those notifications. And
Wow.
finally, what I think it's important to note that it was not considered too much in the papers and academics, but I think it's quite interesting, is the fact that the GDPR is about personal data. So it's really about data that is considered personal, while cybersecurity regulations let's say, are more agnostic in that respect. It's both personal and non-personal data in their scope, because it's not just about the personal data. And also MDR is different on the other hand because it's about the technology. So it's really important to keep in mind that, GDPR is for personal data, but keep in mind that also non-personal data, including anonymized data or pseudonymized data, which are personal data basically,
For sure.
are important as well.
Absolutely. Yeah. It's tough to be a medical manufacturer in Europe. You have declarations with GDPR, with NIS2, with the AI Act, with MDR, and also as well with the group that they made in 2019, the specifications on cybersecurity there. I mean, it's a lot of things. Are there resources that you recommend someone who's looking to have this information centralized today?
Yeah, that's a very good point. At the moment, I don't recall anything specifically. What I think it's the most helpful, it's really the medical device coordination group guidance, although it's very MDR based. So to my knowledge, there is no one holistic piece of guidance that says, okay, you have to do this from this regulation, and it's super updated and it provides a lot of things. No, I have the impression so far that it.
I've looked for it.
That's maybe something to think about. Indeed.
I think so, man. The person who builds this, they're gonna get a lot of friends, I think, because it's a challenge out there finding info. I mean, had to print I don't know how many legislations to try and understand, make so many lists, and it's very confusing. So hopefully, if someone hears this, has a lot of time and the will to do it, please. Elisabetta, it was super fun to have you on board. If people want to find out more about what you do, where can they go?
Thanks for that. Thanks for having me, first of all. And I'm most happy to interact via email. There is my webpage at the Faculty of Leuven with all my publications. I'm also on LinkedIn and Blue Sky. So I'm trying to use Mastodon as well lately, but I just have 2 posts there.
Mastodon. What is this? I've never heard of it.
So it's a decentralized Twitter for, let's say, more nerds, civil society oriented, and it's really interesting. It's less proprietary, it's more open source, etc. So there was this huge debate on that, and I was like, I don't know what to choose. They're different, so I'm in both.
Now that you say it, it rings a bell. It does. I've seen it all over LinkedIn. Interesting. Maybe check it out. That's pretty fun. Well, thanks again, Elisabetta, and hopefully, looking forward to following what you do.
Thank you very much.
All right, folks, what an episode it's been. And here are my top 3 learnings from this one. Number 1, the AI Act specifically includes medical devices under Article 6. Medical devices with AI components are explicitly classified as high-risk AI system. So they do require numerous compliance requirements that are described in Annex 1. Number 2, short incident response reporting windows. There's regulations such as NIS2 that require that the notification period, medical device manufacturers notify the different legislations, the different legislative bodies about incidents. This can range from 24 to 48 hours to sometimes, this depends on the country you're in. So be sure that you know what your timeline is and what are the implications to your processes. And number 3, determine your GDPR role early. You need to understand whether you're a data controller or processor, as it is crucial that determines your specific requirements under this GDPR law. This should be one of the first assessments that you do. Folks, it's been a pleasure having you on. I'm Matthew Peteau, Cyber Doctor, and I'll see you in the next one. If you haven't done so, please subscribe.